Welcome to the Half Empty, Half Full Consumer Advocacy Radio Show. Listen in nationwide on the Tan Talk and Starcom radio networks with your host, Lori Zook, the consumer champion. Each week, we'll be discussing problems and solutions, changing negatives to positives, and helping you, the consumer, to learn something new. Get smarter faster and avoid scams and fraud. All opinions are that of the host and guests, and all shows are for educational purposes only and not to be construed as legal advice. Here's your host, Lori Zook.
And welcome to the show. I'm Lori Zook, and each week we'll be discussing problems and solutions, changing negatives to positives, and helping you, the consumer, to get smarter faster. My guest today is Florida attorney Gregg Heckley, and we're going to be talking about what you as a consumer need to know about estate planning and trusts. Now, Gregg isn't giving legal advice. He's giving strictly educational advice to our listeners because the laws may be different in your state. We're here in Florida. I want to welcome you to the show, Gregg, and share with our listeners a bit about yourself and your background.
Hi, Lori. I moved to Tampa, Florida 30 years ago after graduating from the University of Kentucky College of Law in 1984. I took a job in a tax department of a CPA firm, passed the Florida bar, obtained my CPA license, and started my own law firm in 1987. Although I do not practice as a CPA, I find my knowledge of accounting and taxes important to my clients. I practice in the area of estate planning and probate and have been board certified in wills, trusts, and estates law since 1996.
All right, well, let's jump in right there on the wills and trusts. Explain to me, and if you could put everything in layman's terms, what is the difference between a will and a trust?
A trust is a situation where property is managed by one person for the benefit of another person. In estate planning, trusts can generally be either testamentary trusts contained in wills or separate documents commonly called revocable trusts or living trusts. Testamentary trusts can receive property under the will through probate and qualified death benefits through beneficiary designations. Qualified death benefits would include IRAs, 401ks, qualified retirement plans, life insurance, and annuities. Revocable trusts, on the other hand, can own property as well as being the beneficiary of qualified death benefits. Revocable trusts allow you to avoid probate on assets which you do not have a beneficiary designation or on assets which a beneficiary designation is not appropriate. A will is a document which directs distribution of assets through the probate court. Assets titled in the decedent's name only are transferred by the probate court into the beneficiary's name. Extensive use of beneficiary designations on financial accounts, including beneficiary designations on non-qualified accounts such as checking and savings accounts, allow financial assets to avoid passing under the will and avoid probate. Qualified death benefits, which have a testamentary trust as a beneficiary, pass directly to the trust and do not go through probate.
All right, now, what are the elements to a will, and are they the same as in a trust?
Since wills and revocable trusts distribute property at death, the provisions dealing with death are similar. The revocable trust will also require provisions dealing with the management of property during life and incapacity, since it owns assets during life.
Okay. Now, we're talking about estate planning, but define what that is. What do you need to have in order to have an estate?
Estate planning is determining the strategy and documents needed to benefit a client and his or her beneficiaries in the greatest possible way for situations involving death and incapacity. Any type of asset can be an estate, and there can be a right way and a wrong way to deal with that asset in your estate plan. For example, you never direct the sale of your home in your will because you lose homestead protection from creditors for your relatives. If the home passes directly to a relative under the will, the home is protected from creditors. Likewise, if your home is the most significant asset, you would not want to leave it through a revocable trust because it would subject the home to payment of creditors. If you have many assets other than a home to pay creditors, such as additional real estate and closely held businesses, a revocable trust may be appropriate.
All right. Now, I think you've kind of answered my question here, but should an attorney drop a will, or can I do it myself? I see those forms on the internet or on the computer that say download this form. Is that a wise idea? Because to me, it's sounding like it's not such a good idea after you just explained about how a house might not pass properly and be subject to probate, correct?
Correct. Because estate planning involves knowledge of the laws, you should always have an attorney draft your will. You can draft your own will, but you risk your beneficiary's inheritance if there's a mistake. The other potential mistake is failing to coordinate your beneficiary designations with your will. If your beneficiary designation or joint owner is John, and your will beneficiary is Jane, John will get the property. This is an unpleasant surprise for many people.
Yeah, sounds like it. Now, do I need a trust, and what are the advantages and disadvantages of a trust?
Whether or not you need a trust, a revocable trust in this case, depends on your situation. If you have real property other than your home or closely owned businesses, a revocable trust can save you from having to probate these assets. Attorney cost to probate is generally 3% of the gross value. If you own non-qualified assets, assets where you pay taxes on the dividends and interest, and you cannot use beneficiary designations because beneficiaries cannot manage money, have financial problems, are minors or disabled, or because you desire a complex estate plan where beneficiary provisions would not be appropriate, or where you would fear a will contest, a revocable trust may be the best way to distribute your estate. The advantage of a revocable trust is allowing you to avoid probate at death and guardianship in the event of incapacity. The disadvantage of a revocable trust is that a trustee has the legal obligation to pay creditors, manage assets, and account to beneficiaries. Also, a home in a revocable trust may be sold to pay creditors, and that beneficiary designations may be a more efficient way to distribute assets and avoid probate.
Okay, now I know you're explaining it, but it still sounds tough, and I could see why you need an attorney. Because even if you're listening and you're thinking, well, I could do this myself, if you make one mistake, you can mess everything up for your heirs, correct?
That's correct, yes.
Okay. What items can I leave to someone in a will or trust?
You can leave anything in a will or trust unless there's a law preventing the transfer. For example, absent a prenuptial agreement, a home cannot be left to anyone other than a spouse. If the home is invalidly devised to someone else, the spouse receive a life estate and the children receive a remainder interest. Or the home is split into 50-50 ownership between the spouse and children. This restriction on devise of the home also occurs where there is a minor child.
Okay. Now, what is a payable-on-death designation? I've heard of that. And is a payable-on-death designation a better way to avoid probate than a trust, and how long does probate usually take?
Payable-on-death designations are a better way to avoid probate than a revocable trust because a beneficiary is under no legal obligation to pay creditors, and creditors have a difficult time in locating these accounts and beneficiary. A trustee, on the other hand, has a legal obligation to pay creditors, to manage assets, and to account to the beneficiary. What happens if a trustee makes a mistake? He gets sued. On the other hand, beneficiary designations cannot always be used because some beneficiaries cannot manage money, have financial problems, are minors or disabled, or simply because you desire a more complex estate plan where you give a certain amount to one person, a different amount to another, and so on and so on.
All right. Now, we touched a minute ago on marriage. Excuse me. If I were to marry and my spouse owns the home, what are my rights to the home at his death versus his children's rights if he didn't have a will? And what about other property?
If there's no will, the spouse receives a life estate in the home, or the spouse can elect to own 50% of the home with the children. The spouse also has a right to 2 personal motor vehicles. The spouse has a right to household furnishings and appliances up to a value of $20,000. The spouse may have a right to a family allowance of up to $18,000 for support, and then the spouse has a right to 50% of the other assets.
Now, if I were to get married, is it a wise idea to have a prenuptial agreement nowadays?
Yes, you should have a prenuptial agreement if you wish to protect yourself from divorce or if you wish to protect your children's inheritance. A prenuptial agreement allows you to keep your property and your estate plans separate.
Okay, now, what if I'm not married, but I live with my partner and we jointly own property or bank accounts and one of us dies? What happens with the property and the bank accounts?
Property titled in a joint tenancy with right of survivorship and bank accounts pass to the surviving spouse. But please note that deeds for real property must state owned as joint tenants with right of survivorship in order to pass to the survivor. This is true even if the partners marry later. You should always have a will with a partner as a backup. An unmarried partner has no rights of inheritance under Florida law, and there is no common law marriage in Florida. No marriage, even if the couple live as husband and wife.
Okay, now, is it also a wise idea, whereas you could have a prenup agreement, what about a cohabitation agreement if you're living with your partner? Is that a wise idea also?
A cohabitation agreement would give you the right to sue in the breach of the agreement. The suing party would have difficulty of proving the breach, the damages, and finding assets to collect. A cohabitation agreement distributing the distribution of assets at death would need to be executed like a will with 2 witnesses.
Okay. And does a will or a trust protect me from my creditors?
No. In Florida, a will or revocable trust does not protect you from your creditors. Creditors have to be paid if assets pass under a will or revocable trust unless there's a law protecting the asset. That is why beneficiary designations are so attractive as a means of distributing property. Beneficiaries do not have a legal obligation to pay creditors, and creditors have great difficulty in locating beneficiaries in financial accounts.
All right, interesting. We're going to take a quick break, and we come back. We're talking with Gregg Heckley about estate planning and trusts. Stay with us.
Do you need a private U.S. address for your home business? Do you need help packing and shipping? Are you tired of keeping your inventory at home? Do you need a storage space to store your merchandise? Helpship.com is a domestic and international shipping and packaging service company that can help you with your shipping needs. No matter where you live, we can forward anything to anywhere for you and your customers. Our services range from packing consolidation service, mail forwarding service, shopping assistant, and much more. We're rated A on Better Business Bureau. Expand your business to the globe with us. Please visit Helpship.com for more information.
Do you suffer from back, neck, or body pain? Do you suffer from migraines or have jaw or face pain? Has conventional medicine failed you? Were you injured or in an accident? Call chiropractic physician Dr. Dan Maddock at 813-935-1664. Dr. Dan has helped thousands of patients gain relief for more than 30 years. Dr. Dan is caring, gentle, and takes his time with each patient. He's also a past president of the International Craniopathic Society, a special certification of only 300 chiropractors worldwide. Dr. Dan helps patients from the neck up and the neck down. Dr. Dan accepts most insurance plans. Don't continue to live in pain. Call 813-935-1664 today. That's 813-935-1664 and get on track to better health.
And welcome back to the Half Empty, Half Full Talk radio show. I am here with Gregg Heckley, and we are talking about estate planning and trusts. Now, Gregg, what happens to my property if I die without a will or trust? I think you call that intestate?
Yes.
Okay.
If the property has a joint owner or beneficiary, the property will pass to the joint owner or beneficiary. If no joint owner or beneficiary, the property will pass to your next of kin. This can be complicated if you have an estranged family member or distant relatives.
All right. Now, what happens if I die? And obviously I won't know this because I'm dead, but what happens if someone contests the will and my wishes?
If somebody contests your will, there basically will be a court proceeding to determine whether or not you were competent when you signed your will, whether or not there was undue influence in the execution of your will. Those things are very difficult to prove, particularly if a will was done many years before your death.
Okay. Now, who should have copies of my will or my trust?
I believe you should not give out copies, since you may decide to change your will or trust someday, and you may be awkward requesting your copies to be returned. You do need to let someone know where you keep your documents and give that person the ability to access the documents with financial statements and beneficiary information at the appropriate time. If your original will cannot be found, and there is no reasonable explanation, it is presumed that you have revoked your will by destruction. This is a problem since many documents can be misplaced or lost over the years.
Now, interestingly, I used to keep my will in a safety deposit box until I read an article that said, don't do that, because if nobody else can access the box and you die, they might not even be able to find it, correct? So it's probably not a wise place to put it.
Well, that's not always true.
Okay.
Your will is probably in the safest place in a safety deposit box in terms of fire or theft. And the custodian of the will, which would be the bank, is required to deposit your will with the court upon notification of your death. The problem is if nobody knows that your will is in a safety deposit box in a certain bank, it may be difficult to find.
I gotcha. Okay, that makes sense to me. Now, what is a self-settled asset protection trust? And you can tell I've been reading a lot by coming up with these questions.
Right. A self-settled asset protection trust is a trust created in certain states or countries which protect the settlor, the creator of the trust, from his creditors. This trust is not allowed in Florida. You cannot create a trust to protect yourself in Florida.
Okay. What about a qualified personal residence trust? What is that?
A qualified personal residence trust is a trust where you gift your home to a trust and reserve the right to live there for a certain period of time. If you die within a certain period of time, the full value of your home is included in your taxable estate. If you die after the certain period of time, you are considered to make a gift of the remainder interest, actuarially calculated, and you have removed any post-gift appreciation of the home from your estate. Since the estate tax exemption is currently $5,430,000, and you can use your deceased spouse's unused estate tax exemption through filing a timely filed estate tax return and making a portability election, the use of a qualified personal trust is limited.
All right. Any other advice that you want to give when it comes to wills and trusts?
Do not wait till the last minute to create a will or trust. Testamentary capacity can be challenged if you are ill, and this can invalidate your will or trust. Creating a will or trust is important, but coordinating your assets to these documents is even more important and takes time. More than one will or trust beneficiary has found that they are not receiving anything under the will or trust because the asset was jointly titled with someone else or someone else was listed as beneficiary. Likewise, if the only probate that is to be faced is summary administration, you are usually better off with summary administration than creating a revocable trust, since the costs are equal and the homestead is protected in a summary administration, but not a revocable trust.
So when you meet with somebody, you have to figure out, or they provide you with a list of all of their assets and what their wishes, what they want to have happen afterwards. And because it sounds like there are so many variables that you have to put it together with their wishes and whatever the law says in order to protect whatever assets and make sure they go to the correct parties, correct?
That is correct.
And
yes.
if you make a mistake and try and do it yourself, which I think a lot of people try to do, well, they're not going to be here when they find out their kids or their spouse doesn't get what they wanted them to have.
That's correct, yes.
Okay. Now, I want to talk a little bit about power of attorney. Explain what is a power of attorney and are there different types?
A power of attorney is a document which allows someone to manage your financial and medical concerns. It can be limited to certain matters, such as real estate, although most estate planning powers of attorney try to be as broad as possible to cover almost any situation. There are different types of powers of attorney. The most popular power of attorney is the durable power of attorney, which is valid even if you become incompetent in the future. Ordinary power of attorneys are not valid if you become incompetent.
Okay, what is the difference then between guardianship and a durable power of attorney?
A guardianship is a court proceeding to remove your right to make decisions and to give that authority to a guardian. A durable power of attorney is a private document which gives someone else the right to make decisions for you as you specified in the durable power of attorney. You do not lose the right to make decisions by having a durable power of attorney, and you can revoke the durable power of attorney at any time. You cannot revoke a guardianship without permission from the judge.
So basically, with the guardianship, if I were to become sick or mentally incompetent, the court assigns a guardian, and now really the guardian is making the decisions for me because I'm not competent in some respect.
Correct.
Okay. Now, I think I can answer my own question here, but am I more protected with guardianship or with the durable power of attorney?
You are more protected with a guardianship because there's court supervision, and you can no longer make bad decisions. Guardianship does come at a high cost since it involves attorney representation through the guardianship, which may last years. The attorney and guardian are required to file annual guardianship reports and accountings, which are closely scrutinized. A durable power of attorney avoids these costs and inconveniences, but if a person is uncontrollable or a danger to themselves or their property, a guardianship may still be needed.
All right, now, how should I decide what person is going to be my power of attorney, and can I choose more than one?
Your power of attorney holder must be someone you can trust 110% with your finances. If you do not have that type of relationship, you should not have a power of attorney. A power of attorney holder has access to your accounts. You can have more than one power of attorney, and they can act independently of one another if you desire this flexibility. Your power of attorney should list an alternate power of attorney if that is possible.
All right. Now, what's the difference between power of attorney and executor of the estate, or is that the same thing?
A power of attorney is valid during life. So the power of attorney is different from a executor or personal representative who is appointed by the court to administer your estate.
So the executor is after I die?
Correct.
Okay. And I'm going to ask you the same question I did with power of attorney. How do I decide who should be the executor of my estate? Is that somebody that I am appointing or the court appoints?
Well, if you have a will, you certainly can appoint someone, and they must either be a relative or a resident of Florida. And again, it must be the most trustworthy person you can pick. If this is not possible, you may select a financial institution with a trust department. Often, a personal representative is not appointed by the court because summary administration probate is used. But you need to name a personal representative in the event summary administration is not available or the best choice. For example, a lawsuit needs to be pursued after death, which would require formal administration and appointment of a personal representative.
All right. Now, can I protect my spendthrift child or disabled child's inheritance?
Yes, you can protect a spendthrift child or disabled child's inheritance by setting up a trust. In the case of a disabled child, this trust is called a special needs trust, which will provide only for the child's needs, which are not covered by a government program. Florida allows trusts to be established to protect third parties from their creditors.
All right. Now, what is probate costs, and is there an estate tax?
Probate fees and costs for a summary administration can be as low as $1,600. Probate fees for formal administration are usually 3% of the gross probate estate, excluding the home for relatives, and 3% of the gross estate income, plus costs which may include a bond. Probate fees for formal administration can include additional hourly fees for extraordinary services such as will contests and tax disputes. Florida law does provide a guideline to a presumed reasonable fee, but the beneficiaries can consent to a higher fee. There is a federal estate tax for net estates above $5,430,000. A surviving spouse may claim his deceased spouse's unused estate tax exemption, this year $5,430,000, by making a portability election on a timely filed estate tax return filed 9 months after death. Please note, most trusts were established when the federal estate tax exemption was lower and need to be amended to remove estate tax provisions, or perhaps discarded altogether due to their unnecessary complexity.
Do the laws change with estate planning and trusts frequently or hardly at all?
Well, they have changed quite a bit lately.
Okay.
It comes in spurts. And we had a recent change in the estate tax law in 2012. And for a long time, the estate tax exemption could have reset to $1 million, which would have included a lot of people. But they decided to make the estate tax exemption permanent at $5 million plus inflation in 2012, and currently it's $5,430,000. So as a result, a lot of people that set their estate plans up when the exemption was $1 million have a lot more complexity than they need, and they really need to have their documents amended and reviewed.
I gotcha. Okay. Well, stay with us. We're going to continue on, but we'll be back in just a minute or so.
Do you suffer from back, neck, or body pain? Do you suffer from migraines or have jaw or face pain? Has conventional medicine failed you? Were you injured or in an accident? Call chiropractic physician Dr. Dan Maddock at 813-935-1664. Dr. Dan has helped thousands of patients gain relief for more than 30 years. Dr. Dan is caring, gentle, and takes his time with each patient. He's also a past president of the International Craniopathic Society, a special certification of only 300 chiropractors worldwide. Dr. Dan helps patients from the neck up and the neck down. Dr. Dan accepts most insurance plans. Don't continue to live in pain. Call 813-935-1664 today. That's 813-935-1664 and get on track to better health.
Do you need a private U.S. address for your home business? Do you need help packing and shipping? Are you tired of keeping your inventory at home? Do you need a storage space to store your merchandise? Helpship.com is a domestic and international shipping and packaging service company that can help you with your shipping needs. No matter where you live, we can forward anything to anywhere for you and your customers. Our services range from packing consolidation service, mail forwarding service, shopping assistant, and much more. We're rated A on Better Business Bureau. Expand your business to the globe with us. Please visit Helpship.com for more information.
But committed no crime. Mistakes. I've made a few.
Welcome back to the Half Empty, Half Full Talk radio show. Here with Gregg Heckley. We're talking estate planning and trusts. Now, Gregg, you've given a lot of good information on the powers of attorney. We talked about wills and trusts. In this segment, I want to talk a lot about the Advanced Care Directive, which basically is a medical power of attorney. Can you explain how it works, and should everybody have this?
Medical durable power of attorney or durable power of attorney which has health care provisions is important for everyone because it allows someone to discuss treatment decisions with medical personnel and obtain medical information. It is effective immediately, and this is an advantage over the designation of health care surrogate, which is only effective upon a determination of incapacity by two physicians.
Now, we were talking during the break about different states having different requirements.
State law does vary from state to state, but most states recognize durable power of attorneys from other states. Florida does require 2 witnesses and a notary public for execution of the durable power of attorney. Many states only require a notary public for execution. You know,
I'm thinking of a question that pertains back to the wills and the trusts for a moment. Or even the Advanced Care Directive, the medical care. What happens if you do it in one state and then you move to another state? Do you have to redo everything?
Yes. Once you become a resident of another state, you're under an obligation to comply with those laws.
Okay, because I'm thinking, what if I moved? I might not even think to go about doing the paperwork because I'm thinking I had it done by a lawyer, but there are different laws within the states.
Absolutely.
Okay.
Absolutely.
All right. Now, when it comes to the medical power of attorney, again, who should I choose to be in charge?
The person you trust 110% with your medical decisions. This can be someone different than who you trust with your financial decisions, in which case a medical durable power of attorney will be prepared separately from a main durable power of attorney.
Now, what happens if I don't? What if I'm alone and I don't have somebody I could trust? You know, does an attorney handle that? Can you give that right to an attorney on your behalf?
I would say the answer is no.
Okay.
Even as an attorney, I'm not a durable power of attorney for my clients.
Okay.
That is something that is different. That durable power of attorney places you in the same shoes as you are in. and that will be the only way someone will be able to make decisions on your behalf. Absent that, and if you're not competent, a guardian will be appointed, and that guardian will make those decisions.
All right. Now, are there different options I can choose from if I, become terminal or I don't want to be revived?
If you were terminal and expected to die within 1 year, you can have a physician give you a do not resuscitate form. This form will prevent any efforts to revive you. Any person who is not terminal and does not want to be on life support indefinitely should have a living will so that life support can be removed upon determination that you have a terminal condition, end-stage condition, or persistent vegetative state, which will result in death or has no reasonable hope of recovery. Unless your directions or your medical power of attorney's directions are totally unreasonable, they should be followed. This has led to court cases where there is a disagreement involving blood transfusions and antibiotics and what is in the best interest of the patient.
Yeah, I'm from New Jersey. Years ago, there was a case, I don't know if you remember, Karen Ann Quinlan.
Yes.
Okay, that was in my area in New Jersey, and I don't know if you remember, but there was a big thing because the hospital refused to follow the orders, I think, of the parents at that point because she was a child. They turned it off, and that case went on for months and months. So in essence, the hospital was keeping this person that's alive in a vegetative state. And that's why I think it's important, because I do have the advanced care directive, and I've seen it where it says choose these different options. And I want to read through some of those. I looked them up on the Mayo Clinic's website. Okay, so these are some of the options you have to choose from, and no one wants to think about what happens, and that's why people don't do the advanced care directive. They don't want to think about what happens, but you have to, especially if you have a family. So I'm going to read a little bit. Resuscitation is one option. It restarts the heart when it stopped beating. So you have to determine if and when you would want to be resuscitated by CPR or by a device that delivers an electric shock to stimulate the heart. The next one is mechanical ventilation, which takes over your breathing if you're unable to do so. Consider if, when, and for how long you want to be placed on a mechanical ventilator. Tube feeding supplies the body with nutrients and fluids intravenously or via a tube in the stomach. Decide if, when, and for how long you would want to be fed in this manner. Dialysis removes waste from your blood and manages fluid levels if your kidneys no longer function. Determine when, if, and for how long you'd want to receive this treatment. Next is antibiotics or antiviral medications can be used to treat many infections. If you were near the end of your life, would you want your infections to be treated aggressively, or would you rather let infections run their course? Comfort care includes any number of interventions that may be used to keep you comfortable, manage pain, while abiding by your other treatment wishes. This may include being allowed to die at home, getting pain medications, being fed ice chips to soothe dryness, and avoiding invasive tests or treatments. Organ and tissue donations for transplantation can be specified in your living will. If your organs are removed for donation, you will be kept on life-sustaining treatment temporarily until the procedure is complete. To help your agent avoid any confusion, you may want to state in your living will that you understand the need for this temporary intervention. And last, donating your body for scientific study can also be specified. Contact a local medical school, university, or donation program for information on how to register for planned donation for research. So just by reading through that, you can see how many different things people have to choose from, and a lot of people just stick their head in the sand and, maybe they don't want to do it and they're going to let their family decide, but do you really want to be left on vegetative, in a vegetative condition? Right. You have to make certain decisions to do that. At least that's my feeling. You were talking a bit about the do not resuscitate and do not intubate orders. How does somebody decide? How does someone even decide that?
Well, it is very complicated because we're not doctors and we don't have the background to make a lot of these decisions. But we can certainly make the decision of who we want to consult with our doctor should the need arise. And by having a medical durable power of attorney or even a healthcare surrogate, a lot of these things can be taken care of, even if you're not able to express yourself at that time. But trying to express yourself can be very difficult. And, a living will is not a very complicated document if you've ever seen one.
Yes.
You can add as much to it as you want. But the basic thrust is you don't want to be kept alive indefinitely if you have these certain criteria. And obviously, intubation, certain treatment, all that can be specified as well. It will obviously kind of be up to the doctor, I guess, to determine whether or not that's in your best interest or whether that's life-threatening or appropriate in a situation. But, even though you have all these options, you shouldn't put off having a living will or a medical durable power of attorney, because we've had court cases here in Florida already with the Terry Schiavo situation where she did not have an advance directive. She was very young, and she was on life support for over 10 years. And even after being on life support 10 years, her husband had difficulty getting life support removed because the parents were in opposition. So this is a very important area, even though as lay people we don't really understand it,
right?
Because we don't understand the medical terms and the concepts and so forth. Don't put off making this kind of decision.
Now, when you do this medical directive, is it something that you should provide to your doctor or maybe to your hospital? Do they keep that on file?
This will probably be like your other documents, your will, your durable power of attorney, your and trust. They will probably all be kept together. When you do go into the hospital, you probably will not be seeing the doctor you see for your normal checkups. You could be in another state or facility. So I think you're just going to need to keep that in a place where somebody knows where it's at and has access.
And if down the road, if my medical situation changes, can I change my wishes?
You can always change your wishes as long as you're competent and you can express yourself.
Okay, next one. Let's say I have an elderly family member that's in good health right now. Should I be talking to them about advance directives to find out, do they have one? And if not, maybe get them to do it?
Yes. Any person who desires someone to assist them in their medical decisions should have an advance directive. Parents of college-age children should also consider having their children execute a medical durable power of attorney so that they can assist their children in making medical decisions in the event of a serious accident or illness. Nothing is more frustrating for a family member than not being able to obtain medical information on a loved one because of privacy laws.
All right, now, do hospitals and doctors usually follow my wishes? We were just talking about how they don't always do that. Or do they have to be legally enforced? And if so, can you give some examples?
Hospitals and doctors usually follow your wishes or make you understand that your wishes are counterproductive. For example, you must have a low-salt diet or a liquid diet while in the hospital. Hospitals and doctors have a legal obligation to provide care and warn you of the consequences of not following their direction. If the consequences are not life-threatening, your wishes will probably be honored. If the consequences are life-threatening, hospitals or doctors may seek a legal decision whether treatment is required despite your wishes to the contrary.
All right, and my last question in this segment, what happens if I become very sick and I don't have a living will?
If there is no living will or other advance directive, a physician must find clear and convincing evidence that you want life support removed. This could lead to court litigation, as in the Terry Schiavo decision, if there is no agreement.
All right, very good. Well, stay with us. In the next segment, we're going to be talking about asset protection and more. Back in a second.
I've made a few. I've had my shells and kicked in my face, but I've come through. I need to go on. We are the champions, my friends.
Do you need a private U.S. address for your home business? Do you need help packing and shipping? Are you tired of keeping your inventory at home? Do you need a storage space to store your merchandise? Helpship.com is a domestic and international shipping and packaging service company that can help you with your shipping needs. No matter where you live, we can forward anything to anywhere for you and your customers. Our services range from packing consolidation service, mail forwarding service, shopping assistant, and much more. We're rated A on Better Business Bureau. Expand your business to the globe with us. Please visit Helpship.com for more information.
Do you suffer from back, neck, or body pain? Do you suffer from migraines or have jaw or face pain? Has conventional medicine failed you? Were you injured or in an accident? Call chiropractic physician Dr. Dan Maddock at 813-935-1664. Dr. Dan has helped thousands of patients gain relief for more than 30 years. Dr. Dan is caring, gentle, and takes his time with each patient. He's also a past president of the International Craniopathic Society, a special certification of only 300 chiropractors worldwide. Dr. Dan helps patients from the neck up and the neck down. Dr. Dan accepts most insurance plans. Don't continue to live in pain. Call 813-935-1664 today. That's 813-935-1664 and get on track to better health.
I've made a few. I've had my shells and kicked in my
Welcome back to the Half Empty, Half Full Talk radio show. Gregg Heckley, who is an attorney, we're discussing asset protection in this segment and more. Now, Gregg, how do I protect my assets while I'm alive? Are there legal ways to shield property and money from the IRS, like LLCs or corporations?
There are steps to protect assets while you are alive, although each situation is different. The correct insurance can help protect your assets: umbrella coverage, auto, long-term care, disability, life. Investment in exempt assets such as qualified retirement plans, IRAs, annuities, and cash value life insurance are protected if the investment was not done with the intent to hinder creditors or after a financial problem occurs. Investment in the home is protected unless your investment in the home is done to hinder creditors or after a financial problem occurs and you file bankruptcy within 10 years. Placing a property in a husband and wife's name as tenants by the entirety can protect property from creditors of a single spouse unless done with the intent to hinder creditors or after a financial problem occurs. The best way to protect your money and property from the IRS is to have a good accountant, since the above state law exemptions do not apply to the IRS. Offshore trusts can protect assets but are expensive to establish. Offshore trusts require creditors to relitigate case under unfavorable foreign laws. Corporations and single-member LLCs offer no protection for the owner. Multiple-member LLCs offer protection but would require additional owner.
All right, now what is a fraudulent transfer, and can you give some examples?
Any transfer which is intended to hinder creditors or after a financial problem has occurred and you are insolvent is fraudulent. An example of a fraudulent transfer is giving a car to my daughter so my creditors will not find it, or investing it in an annuity since this property is exempt under Florida statute.
All right, what happens if I own a business and I pass away? What happens to that business, and how can I protect assets under a business?
If a business is not owned by a trust, a revocable trust, the business passes under probate. If the value of the business is small, summary administration may be used. It will be up to your beneficiary in a summary administration or a personal representative in a formal administration to protect the assets in your business.
Now, I read about something called a repatriation order, if I'm saying that correct. What is that?
A repatriation order is an order by the government seizing assets owed to this country by foreigners. For example, somebody who was a citizen renounces their citizenship and moves away, but still owes taxes.
Repatriation order, yeah.
Repatriation order. The government can go ahead and seize that person's assets.
All right. Now, are there scam artists who claim they can do everything an attorney will, but they charge less money? And isn't that practicing law without a license? And the reason I ask that is you can see lots of ads on places like Craigslist where you will have maybe paralegals, which I understand they can prepare documentation, but they can't act as the attorney. But still, you have the scammers, the ones who are, placing these ads. So what about that?
Well, I don't know of anyone personally, but there are a lot of businesses promoting legal services that are not lawyers. The important thing to remember is that these businesses are not licensed or regulated. That is, you do not have any idea who you are working with, and that you are usually given a disclaimer not to rely on their advice because they are not lawyers.
So the consumer has to do their due diligence. And the reason I say this is a lot of times people think I can find someone other than an attorney who's going to charge me a lot less money, but I think that they don't think about what happens if the documentation is not prepared correctly. Then, there's that saying, do it right the first time, because if you don't, the second time it's going to cost you even more.
Correct.
And that's sort of my thought on that. So you don't want to go to someone who's practicing law without a license, and if they are, then you can report them, obviously, correct?
Yes, you can.
Okay. Now, should I be cautious of what information I place on social media? And do creditors' attorneys use that type of information in disputes?
I am sure a creditor's attorney does use that information placed on social media concerning debtors' spending habits and investments.
Okay, and the reason that I ask that is because people who post, for example, on Facebook, now, you can lock your account down to private. Of course, that doesn't mean that someone who's your friend can't then copy the information you posted and put it on their public Facebook page. But I know, for example, people who want to purchase a home, for example, that the mortgage company will go look at their social media sites like Facebook to see, did those people just go out and go on a big vacation? Did they spend a lot of money on an expensive car? They're checking people out. So it made me think, hey, if I were trying to hide something, but maybe I wanted to brag to my friends, I'm going to post it on Facebook, and now people check you on Facebook. Private investigators can check you on Facebook, correct?
Yes, correct.
So I think you want to be cautious. Now, are there tax implications on asset protection plans?
There are tax implications on asset protection plans depending on the asset protection plan you choose.
Okay. As a defense in litigation, I've read that if someone is going to receive a large monetary inheritance, that they should purchase personal umbrella liability insurance.
Anyone who has a large unprotected asset, such as an inheritance, should purchase personal umbrella liability insurance to protect themselves if the liability from an accident exceeds their normal insurance coverage. Umbrella policies can cover liabilities in the range of millions of dollars, whereas normal policy limits are only in the hundreds of thousands of dollars.
Gotcha. Okay, now, what other asset protection mechanisms are there that are legal?
Placing property in someone else's name, if not done as a fraudulent transfer, can act as an asset protection mechanism, although this leaves you at the mercy of this other person.
So it has to be someone you trust if you're going to do it.
Yes.
Now, when someone inherits money, do they pay an inheritance tax or any other taxes?
There is no Florida or federal inheritance tax. There may be income taxes on tax-deferred assets such as IRAs and annuities. In the case of an IRA, a non-spouse beneficiary can make an inherited IRA and take money out over his or her life expectancy, deferring income tax liability.
Okay. Now, my understanding also is if someone's sick and they end up on Medicare, that their assets are used to pay for long-term health care. If that person is married, does the spouse lose all of their assets? And the reason I ask is, let's say, my parents are in their 70s, and one parent isn't doing well and has to go into assisted living, but the other parent is still living in their home or their rental.
Right.
What happens in a situation like that?
Okay. Well, first of all, Medicare is not used to pay for long-term health care.
Okay.
Medicaid is used to pay for long-term health care. If the sick spouse is married, the well spouse can keep certain assets and have a spouse qualify for Medicaid. If long-term care is an issue because of health concerns, I refer such clients to an elder law Medicaid specialist.
Okay, gotcha. All right, because that sounds somewhat complicated. And now, if the person is alone, let's just say it's someone who's not married, and they end up, you're saying, on Medicaid, not Medicare, but are they in essence giving up their assets? And the reason I ask that is, what happens if someone goes into long-term facility,
right,
and they owned a home? In essence, is that facility taking or selling the home to pay for their care, and now they're losing everything because they didn't have a will or a trust?
Well, again, we're addressing a situation while someone is alive.
Right.
And I'm glad you mentioned it. The home is really the most protected asset we have in the state of Florida. And you can go under Medicaid even owning a home. And all that needs to be done is that your person that applies for Medicaid for you must state that you would have the intent to return if you got well again. And that home will be protected if it passes to a relative. However, somebody's going to have to keep up the maintenance and the taxes on that home because that person that goes into Medicaid will not have any assets for those expenses.
So is this a reason, sometimes you read about people that will bequeath while they're alive, so to speak, the property. They'll transfer or quitclaim the property to another family member or maybe their children in order to avoid any problems down the road?
Well, again, we're getting into Medicaid.
Okay.
And all I can say is you don't want to give away your home, first of all, because it's your most protected asset while you're alive. And you can qualify for Medicaid and get all the benefits, and then at the end, at your death, it can pass to your relatives, clear of any creditors. If you give away that home, however, you have just disqualified yourself from receiving Medicaid benefits. So it is something you have to be very careful about because it can actually be a problem.
All right. What's the best way to make sure that children or a spouse are protected?
Proper estate planning is the best way to protect children or a spouse. Failure to do proper estate planning risks your children or spouse's inheritance to unnecessary liability, taxes, and attorney fees. Unfortunately, there is no one-size-fits-all estate plan. A proper estate plan requires an experienced attorney who is knowledgeable about all the laws affecting estate planning. And
how do you find a good attorney in your state? Since we have a nationwide, listening audience, how do you find a good attorney? Maybe referral, but if you don't know someone to ask.
Well, one of the ways you can is in the state of Florida, we do have a certification program that allows attorneys to be certified as specialists or experts in certain areas. And in the wills, trusts, and estates area, there is a certification, and attorneys are certified. You may not find a board-certified attorney in every city, but you will probably be able to find one nearby if that is what you're looking for. But you at least need to find someone who is experienced and knowledgeable in the area.
Great. You've given a lot of good information, and I want to thank you for joining me today. Would you give out your information, Gregg, in the event a listener wants to contact you?
Well, you can certainly check me at my website, greggheckleyyattorney.com, or you can call 813-936-1632.
Thanks again for being here. Join us every week for a new half-empty, half-full consumer advocacy talk radio show. Learn something new every week and get smarter faster. Be safe.
Imus in the morning.
Here is Eddie Murphy. Hi, Eddie.
Forbes magazine said I'm the most overpaid actor. Get out of here. I played 6 parts in Another Professor. Just think how much money the producers would have spent if they paid me 6 times. In Another Professor 2, I played 6 parts again. That's 12 parts for 2 movies. 12. I tell you who's overpaid. How about Jack Black? His last name is Black, but his movie's all in red. Kristen Stewart, they gave her $30 million to look into the camera with that blank stare and take long pauses between her lines. You know why she plays a vampire? Because she's sucking all of Hollywood dry. You think I don't know what this is all about? It's because I'm black. They should have called the article Eddie Murphy is sitting on top of the world in Beverly Hills. But I guess they decided to call it Murphy Sucks because it didn't want to do Beverly Hills Cop 5. Somebody's still mad from bankrolling Pluto Nash. What was I supposed to do? Somebody said, hey man, here's $20 million for this piece of crap. I said, Brandy, Monty, this is my lucky day. This is my lucky day. And I cashed a check, which got me on Forbes' other list, the richest black celebrities.
Catch Imus in the morning, right here on the stations of the Tan Talk Network.
The Buddy Verde Show is always discovering new talent, like Monday Night Football commentator John Gruden's 17-year-old son, Michael.
Your son's going to compose a new Monday Night Football theme? Is that true?
He's going to try. That's why we sent him down there to meet Buddy. Maybe Buddy can point him in the right direction, get us some good advice. This is John Gruden of Monday Night Football and my son, Michael, and we're listening to the Buddy Verde Show, and we love it.
That's the Buddy Verde Show, Saturday afternoon from 1 until 3, here on Tan Talk.